Okay.
Here's a bomb. So I got a client, I was here today.
Okay.
I think she was 7 years now.
Okay.
Um.
Okay. All right. So, Mr. Mamori, could you say something for me, please?
Yes, Your Honor. Good afternoon.
Thank you. We have video and sound. All right. So we're just waiting for your client to be sworn in, then we'll take up that matter.
Thank you, Your Honor.
All right. And Irene Acosta, who do you have?
I have Kendall Smith. It's a bond hearing.
All right. It's Kendall Smith. They'll bring him out.
Thank you.
And Mr. Cantrell?
Oh. It's actually already paid.
I'm sorry, Mr. Callahan. Are you all ready on Mr. Phillips? All right, if y'all approach. Hello, Mr. Phillips. How are you doing?
Awesome.
All right, so here's the thing. You are on bond and they gave you a PR bond and that's through pretrial services. So you must contact them. If you don't contact them, what ends up happening is I get a violation report, right? And I have it set. And when you don't show up, then only one or two things are probably going to end up happening. Either there's going to be a judge's warrant issue or maybe a bond forfeiture issued. Do you have the information for your pretrial services officer?
Yes, I do.
All right, so you're going to need to call her and you're going to need to call her today. Do you understand?
Yes, ma'am.
All right. So State, do you have any objection to the court recalling the judge's warrant?
No, Your Honor.
The only reason why that happened because I just felt they would send me a link saying, hey, call on this day. And I became back homeless and I had no phone. So I was keeping up with, with the calling and checking in.
All right, just 1 second. Norma, can you have the pretrial services officer zoom in? It's Claudio Trevino.
Sure.
They're gonna have them zoom in. And Deputy Laura, on his case, I'm gonna recall the judge's warrant. But before you leave, we're gonna have them zoom in. So they'll have your contact information and you'll know where you need to be, okay?
Okay, and I can give them my new address.
Yes, well, let me ask you this. Do you have a place to stay now?
I still stay in my car because of my diagnosis. I'm schizophrenic, bipolar, PTSD, and like 2 other things that I can't pronounce. Okay. So I take a shot for my schizophrenia that I'm supposed to say today. So I stay in my car because I tend to cause issues with 2 or 3 or more people.
All right, let's do this.
In the house.
Not to step on your toes, but Norma, can you have Renee Munoz come over? He could probably, he has some contact. Oh, Renee, if you could come forward, please.
Like I've been waiting on housing for 3.5 years.
Okay. So this seems to me like this is what the community court would be for. He's homeless, he's living in his vehicle, there are mental health issues. So all of those need to be addressed. He's charged with a drug case. Who knows when the labs are going to be in? It's somewhere out in the universe. So if we could perhaps see about the community court and state, if you're willing to look in that as well to see if that you all deem that to be appropriate for him, so that we can make sure that he has a place to stay and make sure the mental health issues are addressed. The fact that he's taking shots tells me there are issues with his reporting or or either,
I put my mind, I have, my mind is remember short-term and long-term memory, but I was reporting it was like, it was good, but I still had issues. It's just that I just, and it's in and out. It's like that, like I can't stop it. I try to stop it. I try to work on it, but it's something I have to deal with for the rest of my life. I lost best friend because I couldn't understand the symptoms that I had.
well, don't worry. This is what we're going to do. We're going to try to work on things, right? So I don't want to have you get a warrant and maybe you shouldn't have a warrant. So I'm going to recall the warrant. But the key is we're trying to figure out housing for you and trying to figure out making sure that you have a case manager. Because if you had a case manager, your case manager would be able to help you with your memory or at least help stay on top of these appointments you have to
Yes,
make.
ma'am.
Because the problem is it's a drug case
Yeah,
and it's a criminal case.
yes.
And pretrial services want to be able to get in touch with you. And when they can't, that's when they send me the violation report. And I can tell you before I issue a warrant for any violation reports, I'll email the pretrial services officer to see if they've tried one last time to get in touch with the person and if they've been able to get in touch.
Mm.
So if you all could see about community court for him and see about the Center for Healthcare Services, I'm going to recall the warrant.
That's where I go to is for the East Side Clinic.
Okay.
But like, yeah. that's
And
where-
then also, I think the community court will also be able to help you with bus passes if that's an issue. I know you say you live in your
Yeah,
car.
because sometimes I walk to places or because it's easier than driving because sometimes I have wrecks or benders. So I walk or I catch the bus.
All right,
Okay.
so what we're gonna do is I'm gonna reschedule you back. And Norma, were you able to get the email out?
I'm trying to get a hold of the officer and he's not answering.
All right, can you send it to the supervisor that's listed? I'm gonna reset this and I'm gonna reset this just so I can make sure that you're on top of everything. So Norma, we'll recall this. Are you all okay for recalling this? Do you think you have something by the end of February as far as community?
I know that Judge Vada next door facilitates that judge, so I don't have an issue going this afternoon and getting Mr. Callahan the necessary contact information to at least start the process or,
I'll do it.
Okay, so do y'all want to put it at the end of February?
I'll leave that.
Say again,
You all want to put it at the end of February or you think sooner?
2090, Your Honor.
Okay, that would be good to set it in 2090. But so I can bring it back whenever you all want it brought back, just not 2090.
May I see if we get enrolled in that court and then come back and personally report to you?
All right, if y'all want to go over there now then, because I want to make sure he has a sheet of paper in his hand, so he'll at least have that for his date.
yes, Your Honor, would you like us to find out more information and reapproach to see
Yes.
about a date? Yes, Your Honor.
Okay, awesome.
Excuse me, do y'all have a thing where it sends by phone?
Oh, we're gonna see what we can do, okay?
Okay.
All right. So just call, let me know when you all are ready.
Yes, ma'am.
Yes, Your Honor.
Mr. Phillips.
Alexis Gonzalez, Norma,
Be on Zoom, Your Honor.
yes.
Yes, ma'am. I'm sorry.
And State, I'm just waiting for your person to zoom back in for the restitution hearing. All right, where are we on the PTD? And Alexis Gonzalez, you need to unmute and start video. Yes.
So he did get accepted into the program. I conferred with Andrew on it. There's just a term to make sure that he's allowed to be supervised while he's residing in South Carolina. So we're just confirming all that. He already emailed the necessary parties. So once he gets word back from them, then it'll be
All right, when
signed.
will you all know whether or not he can do this out of county?
If you can recall us in maybe a week or 2 weeks.
All right, Ms. Ferguson, I need a 2-week reset on Alexis Gonzalez, PTD, please.
That is belonging. It got lifted.
That'll be February 6th.
That works, thank you.
He's out of state or out of county?
Out of state. South Carolina, yeah.
All right, thank you. He can appear by Zoom.
Okay, and I'll call him.
Okay,
Thank you. You take care, Judge.
thank you.
Thank you.
I'll follow.
All right, Alexis Gonzalez, you're excused. You're welcome. And Norma, you said February 6th?
Yes, ma'am.
And what page is he on?
Page 2, Judge.
Thank you. All right, and I'm so sorry, Irene, who's your client?
Kendall Tishon Smith.
All right, could I see the file on Smith, please?
Right there in the middle. I figured that way.
Hello, what is your name, sir?
Keltan Smith?
Yes.
Step up.
Go ahead.
There you go.
My name is Smith.
Yes. What's your middle name?
Deshaun?
It may be under, they may have filed it under Deshaun. And counsel, which case are you seeking the bond for? Is that the 12136?
Let me pull it up, Your Honor. There was a violation report that was submitted, and this was set for a hearing on the violation report. And
Okay.
I was gonna request that he be continued. He does have a residence where he's able to reside. It would be on, yes, the 12136.
She says it's a violation report.
Done.
Ah, I have it. Thank you. All right, so it shows that he has the violation report. But what is he, I don't understand why he's in custody, because it doesn't show that the PR bond was revoked.
No, but on his under misdemeanors in County Court 9, I believe his bond was revoked in that case, in those cases, and there was a new bond amount that was issued, if I'm not mistaken.
All right, so do you know why he's not reporting? They say he was discharged from the program for not reporting.
His phone wasn't working for a while. I also know that he was no longer homeless. He had found a residence. He had given his address to, I believe, pretrial and the program at Haven for Hope. But I believe that's when his phone stopped working, and he was subsequently picked up on the violation report in County Court 9.
All right.
But he does have a residence that he can go to, Your Honor.
All right, have you conferred with the state on the underlying case? Have you conferred with them on this possession less than a gram?
I have conferred with them, and they have submitted an offer But I would like to review the evidence some more with my client prior to advising him on any kind of plea.
All right, Ms. Ferguson, on this case,
Yes.
we're going to recall this for the week of January 27th. What day? How old are you?
20.
All right.
I can do the 30th.
All right, we're going to recall this case for January 30th. And then with regards to this violation report, this isn't on the record.
Yes, ma'am.
You need to report to pretrial services, period. That was a condition of your bond. It's not a condition that I said, it's a condition that another judge said. You just can't disappear. If you're on bond, you have conditions of bond. Do you understand?
I do.
So what I'm going to tell you is,
Harris?
and they're saying that you need to comply with the special needs conditions of Center for Healthcare Services. Have you made contact with them?
Not
Did
yet.
you ever make contact with them?
I was trying to.
Well, I mean, Center for Healthcare Services is pretty, pick up the phone and call.
I didn't know the number or anything like that. My phone just stopped working.
Have you ever had treatment before? Have you ever seen a psychiatrist before? All right. This is what's going to end up happening. Counsel?
Yes, Your Honor.
Oh, thank you. Sorry. Just one moment. Thank you, Norma. Okay, counsel, I'm going to allow him to be released. You're going to need to report for Center for Healthcare Services, and you are going to need to get in touch with pretrial services upon your release.
Yes,
They're
ma'am.
probably going to release you at midnight, but when they release you, the very first business day during business hours, you need to contact them. Do you understand?
I do.
So Norma, I'm going to put on here, and your attorney will give you a copy of this, that you need to report to pretrial services no later than Friday, the 24th.
Got you.
Okay.
Your
And
Honor.
also, Norma, if you'll give him a reset form for January 30th.
Yes, ma'am.
Your Honor,
Yes.
can it be included that he's allowed to live at his residence and not at Haven for Hope? It's my understanding that that was a confusion.
Who's at the residence with you?
My family. My
All right.
wife.
Are there any children in the household?
No.
All right. All right, Deputy Laura, can you give him a sheet of paper? And I want you to write down your address on that sheet of paper that Deputy Laura is going to give you, and I'll include that in the order. And Norma, if you'll give him a reset.
Yes, ma'am. I have right here.
Thank you, Your Honor.
You're welcome. Is there anything else, counsel?
No, nothing further from me. May I be excused?
Yes, you may be excused.
Thank you.
All right, and are you all ready on the, yes?
Your Honor, told that, because of felony pendings, two different classes of drugs, it's unlikely that he will qualify for community court, but I have the number to verify whether that's true or not. And also, I will visit with the DA to see if they were willing to drop to misdemeanor. I suggest that the court give us a setting within 2-3 weeks.
All right. All right, Mr. Phillips, Norma, on this case, if you can give me a 2 to 3 week reset, please.
Thank you, Judge.
You're welcome.
February 13th.
All right, thank you.
Please.
And Norma, if you'll make sure that he has a reset form. All right. Are you already on the restitution hearing?
So.
All right, if y'all will come forward. Thank you for your patience. We're back on the record in 2024 CR 3316, State of Texas versus Ezekiel Neely. Can I have parties again re-announce for the record for the state? Thanks.
Good afternoon, Judge Alfonso Cabañas for Ezekiel Neely.
And are you Mr. Neely?
Yes, ma'am.
All right, so I believe the first witness you have, state, is Gabriel. All right, Gabriel Cervantes, if you'll remove the. All right, Mr. Cervantes, are you able to hear us?
Yes, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Gabriel Guadiana Cervantes.
All right, any objection to this witness appearing by Zoom, state? Defense?
Not from a defense counsel, Judge.
All right, and Mr. Neely, you have no objection to this witness appearing by Zoom?
No, ma'am.
All right, state, you may proceed.
Mr. Guadiana Cervantes, can you hear me?
Yes.
Okay, you previously testified that on November 4th of 2023, a vehicle struck your vehicle. Do you recall that?
Yes.
And what vehicle was that?
It was the black Kia Soul.
And what vehicle were you operating at the time?
I was in the Dodge Challenger, white Dodge Challenger.
And what damages did that Challenger sustain?
Rear and front damages, mainly on the rear.
All right, have you had those damages repaired?
Yes.
What was the cost of those repairs?
A little bit under $8,000.
And that's an amount that you have already paid to the repair shop that performed the repairs?
Yes.
Your Honor, can I object to this line of questioning? I believe that Mr. Guadiana Cervantes has testified to this before. The purpose of today's hearing was so that Mr. Cervantes could show the court and the state his bank records, proof that he did in fact pay that amount. He claimed last time he paid it with cash. He's already testified to this before. We're just here to determine whether or not he does have proof of bank records that show he did in fact pay that amount he's claiming.
All right, defense's objection, I guess, is asked and answered.
Asked and answered, Judge?
All right, that objection will be sustained. We are here for bank records or some type of receipt to show that that amount has been paid.
Mm-hmm.
Did you receive a receipt from the repair shop that performed the repairs?
Yes, I did, but I mean, I don't have no proof. So I don't have no proof. I don't even own the car anymore. The car, I already sold it off. So I mean, it's all right. I'm just wasting time, honestly, from work. It's all right.
All right, thank you so much. So Mr. Cervantes, it's just that I need proof of the amount that's been paid.
Yes, we spoke about it. I couldn't get no proof from my bank or from Mr. Robert from the auto shop. I think somebody called Mr. Abraham, and he said that he will like testify and say that he actually fixed my car, but I don't know how that works. I haven't looked into it at all. I've been busy at work.
All right, thank you so much. I appreciate your coming in.
Okay.
All right.
Am I cleared to go or?
Anything else for Mr. Cervantes?
Not from the state?
Not from defense counsel, Judge.
Yes, thank you. Be careful and stay warm out there.
Thank you.
All right. All right, any other witnesses?
Yes, James Kirkland Tartar.
All right, Mr. Tartar, if you could raise your right hand for me, please. And I'm sorry, and unmute.
There we are.
All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
James Kirkland Tartar.
All right. Any objections to this witness testifying by Zoom, state?
No, Your Honor.
Not from
Defense?
defense counsel, Judge.
All right, state.
On November 4th of 2023, were you involved in an automobile collision?
Yes,
And did you suffer personal injuries as a result of that collision?
I did.
Would you please describe the circumstances of the collision?
Judge, I'm gonna object to asked and answered. The supplemental report that we have shows that Mr. Tartar was reimbursed from his insurance company for the amount of $7,822.78. So he has no more claim for restitution unless he's trying to double dip. But Mr. Tartar's been paid in full.
All right, Mr. Tartar, have you already been paid through insurance for the amount of restitution?
What they paid, the $7,000 was for the damage to my vehicle.
Okay. And so what are you asking for payment for then?
For the outstanding amount from my health coverage, from what the hospital, my insurance did not cover from the hospital. I had a $500 deductible and almost a little over $8,000 that my insurance would not pay.
All right, if you want to address those issues, and I will tell parties if my understanding of the law, if he's out of pocket his deductible, then that needs to be paid.
Yes, Your Honor.
All right, so I'm assuming both parties can agree that the deductible of $500, if that has not been paid by insurance, which won't because it's a deductible, that he is definitely owed $500. Is that correct, defense?
Yes, Your Honor.
All right, so we already have the $500. You will definitely receive restitution for that.
Thank you, Your Honor.
All right, now let's address the other issues. He's saying that there are some medical bills. If y'all want to question him concerning that, please.
Mr. Tartar,
Yes, sir.
what services did you receive after this collision?
It was an examination and x-rays, and then they gave me some pain medication.
And how much were you billed for this examination and x-rays?
Over $8,000. I sent the receipt to Mr. Edelman. Or it wasn't a receipt, it was the explanation of benefits from my insurance.
And the explanation of benefits, was that amount 8,262?
Yes,
And is that what you are expected to pay by your insurance company?
yes, sir.
Okay, pass the witness.
All right, defense, any questions?
Yeah, Mr. Tartar, this explanation of benefits, the $8,262, is this for services that were rendered due to the collision?
Yes, sir.
Okay, and these services, did you have any pre-existing injuries?
No,
before this
sir.
accident?
No, sir.
Okay, did you hire a plaintiff's attorney to file a civil lawsuit as a result of the injuries you sustained?
Objection, relevance.
Overruled.
I indeed tried, sir, and all the lawyers I tried would not take my case.
Okay, and out of pocket, you paid only the amount of $500, is that the correct deductible amount?
Yes, sir.
So the amount outstanding of $8,262 has not been paid by you, or did you pay
No,
that already?
sir. It has not been paid yet.
And did you submit those documents to the prosecutor for Burke County, Mr. Andrew Edelman,
Yes, sir. I sent it to him yesterday.
just yesterday?
Maybe.
All right, and counsel, have you received those?
No, Your Honor.
Mr. Edelman, do you have those to give to defense?
Figuring out a way to send them as quickly as possible.
And counsel, I know you're receiving these just now, so if you need more time, just let the court know.
I probably will ask for more time to review them, Your Honor.
All right. So other than that expense that you had, the deductible and the $8,262, is there any other expense that you have, Mr. Tarter?
No, ma'am.
All right. So any other questions, state? Okay. All right. I can tell you with regards to Mr. Tarter, with regards to the $8,262, you haven't seen anything on that, so I don't feel comfortable or legally that I should give him the $8,262 in restitution until defense counsel has had an opportunity to review those documents. So Mr. Tarter, I'm not saying that you're not going to receive that restitution, or I'm not going to order that restitution. It's just that the defense counsel needs an opportunity to review it. Do you understand?
Absolutely, Your Honor.
All right. And sir, we may need you to come back in case the defense needs to recall you as a witness as it relates to the $8,262. Do you understand?
Yes, ma'am, I will be available.
All right. And then defense, I know you just received that, but is there any other questions you need to ask him about that?
No, not at this time, Your Honor.
All right, so we'll make sure that you know the date and you can appear by Zoom. No objections to his appearing by Zoom, state?
No, Your Honor.
Defense?
Not from defense, Your Honor.
All right, you may be excused, sir.
Thank you very much, Your Honor.
You're welcome. And then the next person, state?
Mr. Arnulfo Pineda.
All right, if you could unmute, sir. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record.
Arnulfo Pineda.
All right, any objections to this witness appearing by Zoom, state?
The state.
Defense?
Not from defense counsel, Judge.
All right, state, you may proceed.
Mr. Pineda, were you on November 4th of 2023, were you the owner of a black Kia Soul motor vehicle?
Yes.
And on November 4th of 2023, did you have it in your possession?
Yes.
Was it involved in a collision?
Yes, that's what I was informed of.
And what damages did that vehicle sustain?
It sustained damages along the front of the vehicle. It was totaled out. I was not able to get it back. It had the airbags deployed, cracked in the windshield. Lots of stuff was just thrown around inside the car.
Was the vehicle capable of being repaired?
I don't know if it was able to be repaired. I didn't have any money to repair it, so it sat in the impound until they took possession of it.
And at the time that you owned the vehicle, what was its fair market value?
It was just under $9,000. I don't remember exactly what it was. I gave it to the detective at the time.
Thank you. Pass the witness.
All right, defense?
Thank you. Mr. Pineda, your car was, would you remind me, it was what kind of make and model?
The make and model was a 2015 Kia Soul.
When you purchased it, was it brand new or was it pre-owned?
It was brand new
When did you buy it?
in 2015.
Okay. And if you recall, how many miles did it have at the time of the accident?
I believe it had 124,000 miles on it, if I can remember correctly.
Okay. The accident that occurred on November 4th, 2023, it's your testimony that the car sat in the impound lot, so it was never sent to any repair shops for any estimates, correct?
Correct, because it was not drivable.
Okay. And you just testified that because you didn't have any money at that time, no repairs, or you didn't pay anything out of pocket, correct?
Correct. I did not have any money to pay for the repairs or to get it towed anywhere, so no, I could not get it to anybody to give me an estimate for repair.
Okay. Now, the 2015, was your car paid in full by the bank or whatever
Yes.
insurance you may have had at the time? It was paid in full?
It was paid off. I did not have a car payment.
Okay, was your car insured?
Yes, it did not have full coverage. It only had liability because it was already paid off. I didn't hear you correctly, but it stayed in the impound lot, so you did not pay any money, nor were you charged anything to get it removed from the impound lot, right? Correct.
Okay. And your car was paid in full and you only had liability coverage?
Correct.
Okay. And then the fair market value, is that something that you researched at the time or today, or how did you come across that fair market value?
It was a Kelly Blue Book value that I researched the day that the detective spoke to me. I believe it was the day after.
Okay. Okay. And just to make sure that I understand you correctly, because you have liability coverage, you were not given any money from the insurance company, correct?
Correct.
All right. And, okay, no further questions, Judge.
One more question, Your Honor.
Yes.
Mr. Bruneta, what was the total amount that you paid for that vehicle?
When I bought the car, the value of the car was $25,000.
Thank you.
All right, I have a few questions if there are not any objections.
None from defense counsel, Judge.
State, Your Honor.
All right, so you bought it for 25,000, and when did you buy it? Do you remember the year?
2015.
And how much are you saying the the Kelly Blue Book value was?
At that time, I believe it was like 8,920 or 30 or something like that.
Are you saying 8,900?
Yes, ma'am.
And so that would have been in 2023?
Yeah.
And when you say that as the Kelly Blue Book value, was that fair or new? How did you rate it? Because usually, unless they change, it has fair, new.
Yes, I put it in under fair.
Okay.
Because it wasn't brand new, so I knew that, and I knew it wasn't on the low end either.
Okay. And I'm sorry, can you tell me again the make and model?
A 2015 Kia Soul.
All right, any other questions?
I have a couple more from defense.
Yes.
Mr. Burnett, I forgot to ask you, as a result of this accident, did you hire a plaintiff's attorney to file a lawsuit against the insurance company?
No, I called two different lawyers, and both of them told me that with the value of the car, if I was to pursue that avenue, that I would basically walk away with almost nothing, and I would have court fees to pay on top of it. So it didn't seem like it would be a smart move or investment on my end.
Okay, but to make sure I understand you, so you talked to two lawyers, both of these lawyers said that you would walk away with close to nothing. Is that right?
Correct.
And, okay, and so now you're asking the court to award you something close to the fair market value of the car.
At least, yes, because I had to take a loan. I had to take a loan out of my 401k to replace the vehicle, so I'm also out money from my 401k for the same reason.
Okay, how much money did you take out from your 401k?
$9,000.
Okay, and who's your 401k, who's your provider?
I don't remember off the top of my head. It's through my employer. I work for Marriott.
Marriott, okay. When did you take out that 401 amount from your 401k?
In December. The December after the theft.
So December 2023?
Correct.
Have you provided proof of that 401k withdrawal to Mr. Edelman with the Bexar County Prosecutor's Office?
No, they haven't. They did not ask for that. I didn't know I needed to get that.
He didn't ask you for proof of that?
No. I can get it, just not at this time.
Nothing further from defense, Your Honor.
All right, anything else from either side?
State.
All right, and this is your last witness?
Yes, Your Honor.
All right, so do parties stipulate that the $8,900 is the value of the 2015 Kia Soul at the time from 2023?
State does.
The defense does, Your Honor.
You do?
Yes.
All right. So then unless there's proof that he's received payment for that, that amount is going to have to be paid. So is there any objection to the restitution amount being $8,900 for the vehicle?
State, Your Honor.
I mean, Judge, I would object just on procedurally that there's no evidence to support it, right? I mean, there's no documents other than his word, but there's nothing that Mr. Brunetta, has given to the state of Texas to confirm that amount.
Mm-hmm. Well, I can listen to his testimony and make a determination on whether I think he's a credible witness or not. What I can tell you, sir, is that the money you took out from your 401k, I know how it is. Sometimes when you take money from the 401k, you get hit by taxes and hit by other things. And of course, you don't have that savings anymore.
Correct.
Legally, I can't give you restitution for the amount you took out of your 401k and any type of financial burdens that you had because you took out the 401k. The only thing I can give you restitution for is the vehicle. So is there any doubt from either party that this vehicle was totaled?
State.
Judge, there's that from the defense.
When I was arrested, I was told that it wasn't told.
Well, I mean, here's the thing. You can be placed under oath to give your information, but what I'm telling everybody, if this vehicle was at the impound lot, did you ever remove it from impound, sir?
No, I was, like I said before, I wasn't able to afford it because when I went, it was over $500 at the time to get it out, which I just didn't have. So the only thing I was able to do was remove a few items from my car that were mine. And that's also when I took the photos and I was able to realize or determine that my son's stroller and car seat were also missing.
So you never obtained the vehicle from the impound?
No, I was not able to get it out of the impound.
All right. So there should be proof that the vehicle was never removed from impound by him. And if that's the case, then he's entitled to the $8,900. His vehicle was totaled. He had to take money out of his 401k. So state, I'm sure you're able to get evidence that this vehicle was never removed from the impound lot by him because you have to sign out for that. Are you able to obtain that or no?
No, Your Honor, I've never tried.
Okay, it can be done, trust me. So this is what the court is going to order with regards to this witness. State, you're going to provide the defense with proof that he never
That the vehicle was never removed from the impound lot, Your Honor.
by him. Vehicles can still be removed. Sometimes it's somebody else. Sometimes they end up selling it. But they should have a log book of whether or not the vehicle was removed by him. And if there is no log book that shows that he removed it, I'm going to grant the restitution amount for $8,900. Is there anything else from either side?
Not from the state, Your Honor.
Not from defense, Your Honor.
All right, and sir, this is what I'm going to do. This case is going to come back because another witness needs to have some more information for the defense to review. And we're gonna come back in 2 weeks, and that'll give ample time for the state to have pulled the impound records to show that you didn't remove the vehicle.
Okay.
All right, is there anything else from either side?
Nothing to state, Your Honor.
Not from defense, Your Honor.
All right, Ms. Ferguson, can you give me a 2-week reset date?
February 6th.
All right, so sir, it's gonna be February 6th. If you want to zoom in for that, you can. But on February 6th, we're off the record, so everybody's clear. Tarter, it's for the defense to review the medical records, to be able to ask whatever questions you want to ask for that. And then it's for the state to check with the impound to see if this witness ever removed the vehicle. Not that the vehicle was removed, because it's probably been sold for scraps or whatever. It's to see whether or not he actually removed it. Does everyone understand?
Yes, Your Honor.
All right. We will see you back on what date again, Ms. Ferguson?
February 6th.
We'll come back on February 6th. If you'll sign the reset form, and counsel, if you want your client to appear by Zoom, you can appear by Zoom.
Yes, Your Honor.
All right, thank you.
Thank you.
Yes.
Thank you, Your Honor.
Yes.
Once you're done, can you check if the pretrial officers and then there's a.
No, there's no pretrial officer.
May I?
Oh, yes.
I'm
you may-
sorry, may I leave?
Yes, thank you so much.
Thank you.
Welcome. And Mamori, who do you have?
Your Honor, I have so many files on my desk. I have a plea on, Contreras, Judge.
All right, Mr. Contreras, if you'll come
Yes,
down,
ma'am.
please. And Norma, what page was Neely on? All right, thank you. The court is calling 2024 CR 012263, State versus Miguel Contreras Jr. Can I have parties announced for the state?
Andrew Harris Edelman.
Defense?
I'm here, Mamori.
And are you Mr. Contreras?
Yes, ma'am.
All right, Mr. Contreras, do you have any objections to your counsel appearing
No,
by
ma'am.
Zoom?
No, ma'am.
All right. State, any objections to the defense counsel appearing by Zoom?
No objection, Your Honor.
Counsel, have you received all discovery?
I have, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Contreras, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving the repeat offender enhancement allegation.
Any objection?
No objections, Your Honor.
Mr. Contreras, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I do, yes, ma'am.
Did you understand you're charged with evading arrest detention with a previous conviction? That is a state jail felony.
Yes.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
No. Yes, excuse me.
Okay, no
Sorry.
problem. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Contreras, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
No.
According to the plea, the state recommends deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor, with one caveat, there are 2 misdemeanor cases that the state will take into consideration that I failed to note on the bargain page.
Any objections to the court writing those numbers in, defense?
No, Your Honor.
All right, and which case numbers are you taking in consideration?
Read those, welcome to chime in.
Would it be the resisting arrest, search or transportation and failure to identify?
Yes, Your Honor.
All right,
2024 PF 13390 and 2024 PF 26344.
all right, so how they have it listed on the docket sheet?
As 2024 CC 740762 and 2025 CC 000160, Your Honor.
Yes. So are
Yes, Your
those correct numbers?
Yes, Your Honor.
All right, so the state will be taking in consideration 2024 CC 740762, which is a resisting arrest, search or transportation, and 2025 CC 000160, which is a failure to identify. Did you understand that to be the plea, sir?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Containing Exhibit 1 and attachments, Your Honor.
Any
No
objections?
objections.
State, you may be excused. Did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, state. There's a page 2 of the police report is missing. Mr. Memori, do you have any objection to the state amending the waiver to include page 2 of the police report?
No, Your Honor.
Yeah, for sure.
Yes. Thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Do you wish to proceed with sentencing, counsel?
Yes, Your Honor.
All right, is there anything you wish to say on behalf of your client?
That we respectfully ask the court to follow the agreement between the state and defense.
All right, do you have any children?
Yes, ma'am.
What are their ages?
They were born 2006, 8, 10, and 12.
I'm sorry, what?
2008, 6, 10, and 12.
Okay.
6, 8, 10, and 12.
Okay, sorry.
Every 2 years.
All right, and do they live with you?
No,
When's the last time you've seen them?
it's been about 5 years.
Why so long?
I was in prison.
Okay.
Ever since then, I haven't seen them since.
All right, how far did you go in school?
I was graduated high school and went to the Marine Corps when I got out.
And how did you went to the Marine Corps? Was that was that an honorable
I
discharge?
got a back counter discharge.
I'm sorry?
A back counter discharge.
All right. So how did you go from being in the Marines to being here?
Long
What
story.
happened?
There was a grand larceny case that I didn't report, and I ended up going to the brig for it, and then between then to me getting out of the brig, I had 8 charges stacked on me. I was facing 33 years. They lowered it down to accessory after the fact and failure to report grand larceny, conspiracy, whatever.
So when you were released from the brig and when you're out of the military, how do you keep picking up cases here? What's going on with you? Is there a mental health issue? Is there a drug issue?
Homeless. I really don't have a place to stay at the moment.
Well, the problem is once there are some issues, I don't know if the military or if there are any issues available for you because of the way you were released from the military. We can have somebody come down and see. But Sean, can you see if Herman is able to come down and just to talk to him? You're not going to qualify for Veterans Treatment Court or anything of that nature because of it's not an honorable discharge from the military. So what are you planning on doing with the rest of your life?
I'm not sure yet.
Okay. Do you have something for me?
This, Mrs. Your Honor, may I?
Yes. Well, I mean, how old are you?
I'm 40.
All right, you have to come up with some ideas. Otherwise, we're going to see you back here.
I understand.
So has there been any type of drug use with you?
I smoke.
What do you smoke?
Some meth sometimes, and some marijuana.
All right, you say crystal meth and what?
Cigarettes.
You say crystal meth, cigarettes, and marijuana?
Yes, ma'am.
Okay. When's the last time you smoked crystal meth?
Before I got arrested, not too long.
Mhm.
But I don't do it. I don't want to say I'm not addicted, but I don't.
Well, how often were you smoking?
I'm sorry.
How often were you smoking meth?
Maybe like twice a week,
Okay.
at least, maybe.
All right. So this is what the court is going to do. Court is going to follow your agreement, 4 years deferred adjudication. Counsel, I don't want him to be unsuccessful on this, so I'm going to do a TAP evaluation and do it in custody. It shouldn't take that long for the TAP evaluation to be completed, and we'll follow TAP recommendations.
Your Honor,
Yes.
may I present to Mr. Contreras copies of these?
Yes.
Thank you.
There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment, within 35 days of release, no employment as a home health care provider or with minors. 200 hours of community service restitution. I'm gonna require parenting classes. Once he completes that, then 100 hours will be deemed satisfied of the community service restitution. The other 100 hours will be deemed satisfied if you complete some type of trade school or something to better yourself. You understand?
Mm.
Or if you go to college. Field visits 1 time per month.
What's the field visit?
Oh, they're gonna come out and visit you at your
Okay.
home, probation. And that's gonna be until further notice. Taking consideration 2024 CC 740762, 2025 CC 000160. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. We can go off the record, sir. In this court, to be successful on probation, communication is key. Make sure that you stay in touch with probation. If you feel that there's an issue they're not addressing, you can always come back to the court. Do you understand? The other thing, if there's a sidewalk that is provided, you must walk on the sidewalk. If you are not walking on the sidewalk, the police can stop you. Do you understand? All right, good luck to you.
Judge, what day are we coming back for the tap?
Oh, there is no day to come back. If the TAP evaluation recommends inpatient treatment and you all don't agree with that, you can ask the court to set it on the docket.
Thanks, Judge. May I have excused?
Yes, thank you.
Thank you, Judge. I'll be back.
Who's here on Rakim Asore? Come down, sir. Oh, I'm sorry, can I have that back?
Oh, yes, Judge.
I just need to put it in the system. All right, today is plea deadline date. So is this going to be a jury trial?
Judge, I have, my investigator, who I just recently got appointed, came up with some new information that I would like the opportunity to share with the district attorney to see if we can do a new plea bargain. So I would be asking for a couple of weeks to share that information, Judge, to review it and to share it.
And it's my understanding, Your Honor, that defense just recently got them like yesterday, if I'm not mistaken.
That's correct,
So we
Judge.
would also like an opportunity to review what she has received.
All right, this will be your final plea deadline date. Ms. Ferguson, 3 weeks. All right, February 13th.
Thanks, Judge.
All right, thank you.
Have Allen, you still have the Allen case?
Yes.
Okay,
Oh,
ready.
they're back. Okay.
They're ready whenever.
Okay, Alan, who's here for Alan?
You mean Jonathan?
Yes.
One of those ones with two.
All right. So, State, did you have a chance to talk to the complainant in this case?
We did, Judge.
All right, so are we still on the same page, or do you all want to talk to public integrity?
This time, oh, sorry.
Yes.
Judge, we've reviewed, actually, in the meantime, in the interim, the prior statements and prior videos, body cam, those kinds of things from the original offense states. I'm going to talk to Ms. Kane about what's going to be entailed to go forward with the conviction integrity unit. I'm pretty familiar with them. I know what they're going to kind of require. I don't know that it's gonna be something to go forward, but it's obviously something that she's wanting to do. So I think it might be something that I'll let her at least talk to them and point her in the right direction. I don't know if it'll be successful, but we'll point her in the right direction, Judge.
All right. So where we are is the no harmful or injurious contact. My understanding is that the request is that the no contact order be lifted. And the reason why that no contact order is in place is due to the nature of the case. So state, are you in agreement to removing that or no?
They're not.
Right.
Not only due to the nature of the case, but also due to the behavior that's exhibited in this supplemental report, the not abiding by the no contact order in the first place, and also his discharge from Salvation Army for disorderly conduct. And the state has been made aware that maybe his medication is not stable as well. And so for those reasons, the state is concerned for the complainant's safety and would object to changing.
All right, so do all parties agree that there's some mental health issues going on in this case?
Yes, ma'am.
So here's my question, and I'm not gonna say he's in violation of the no contact order today. How did he get here today? Did his mom bring him?
He did with permission from probation.
Okay,
It's something that she screened because he doesn't have any other transportation. That's part of our problem here. He can't get to his psychiatrist to be able to get the proper medication. So, and to get evaluated for that medication because he can't get there. The only medication he's getting right now is through MIC. And it is,
do they have,
not Cymbalta. It's a newer generation bipolar medication to treat his depression. The problem we have though is that he has a schizophrenic component as well as the bipolar depression. So he's essentially a schizoaffective disorder, bipolar type depressed. So he's got to have an antipsychotic that gets added into that mix.
so is he able to take the VIA bus?
In his current state, probably not.
Okay,
I don't know that he can navigate that, Judge, and that's part of our problem. He's currently residing in a house that is owned by his mother, but is not with his mother.
okay.
His mother is the guardian of his children, and she's very protective of them, especially if Mr. Allen gets into a state where, you know, he's having his symptoms being exacerbated. She's very conscious of making sure that those kids are protected. And it's mostly just from seeing him in that state where they would be confused and not be able to understand what was happening.
All right, do we know if Center for Healthcare Services provides transportation?
They will if you are involved in one of their FACT Act or AOT programs.
Yeah.
But you got to be involved in one of those programs in order for them to be able to provide that kind of a service. Honestly, Judge, to address the issues that were raised, he was staying at Salvation Army. My experience with Salvation Army is if you don't go out and work for them, they're going to kick you out. If you don't give them your food stamp card, they're going to kick you out. Because that's basically just kind of how they operate and how they make money to fund what they've got to fund. I don't know what happened. I don't think any of us have. We don't have that evidence in front of us. But my client needs a place to live and he needs a way to get treatment. That's really what we're talking about. He's not going to be living with her. He's not going to be, you know, in a constant contact or anything like that. We just want it so that if he needs some help, she can provide that help to him.
Well, who stays with the children if she's transporting him?
She's right now, she was supposed to pick them up from school. She made arrangements to get friends of the family to do that. And so she's got arrangements and has people that can watch the children. And they're school age, so they're in school during the day.
So what is the answer to this issue? Because I'm looking for transportation now for persons who are suffering from mental health issues. And I'm not finding anything in San Antonio.
There isn't.
I don't know that the state can speak to that. All the state can speak to is the concern for the safety of the victim in this case. And that's where my concerns lie with putting them in contact with each other. I don't know if maybe the other family members who are watching their children can maybe instead take the defendant. That might be an option.
What I would say, Judge, and it's probably is, and please don't take this the wrong way,
No.
but one of the allegations is that Mr. Allen's been in contact with his mother
Mhm.
repeatedly. And I think that even says in the probation's report that got us here today,
Mhm.
that he is not, and it's hard for him to really understand that order. But what I would say is, despite all that, there's been no incidents of
Mhm.
any kind of violence or any kind of aggression or anything during this whole time.
Just so the record is clear, the disorderly conduct was noted in the supplemental report. So I don't want to disagree with Mr. McLean, but I don't think that's entirely accurate. I was speaking with probation and they do have an option for transportation.
Okay, yes.
So we did have a presentation by the Access Program, which is through the Center for Healthcare Services.
Mhm.
And from what they relayed, it's a branch out from the MIC program.
Mhm.
So they do offer transportation services if they're accepted into that program. I don't know what the screening would entail. I'm sure if he's in the MIC program, there's probably likely that he could be in with the Access Program as well, but that would be something that we could send a referral and see if they could assess that. But as you know, it goes with the center and whatever appointments he has with their case managers.
Oh, and we have someone here in the courtroom now.
Go look around.
Renee, come forward. All right, so we're trying to find transportation for him. Mental health issues.
I was looking, Judge, I couldn't help it over here, Via Trans also, is through with the Via bus system, but for people with disabilities that can't make it on a normal bus, so I don't know if that's maybe an option as well. But if you're looking for a particular program, I would guess need some more information, but.
And I will tell you, my concerns are the same concerns that the state have, because we're here for an injury case. And then we're having transportation. Today, everything is great. But what if everything is not great with the contact?
And I honestly, Judge, I share the same concerns, but having spoken with Mrs. Kane and her being so adamant that she does not have these concerns, to some degree alleviates my concern. I understand what the court's saying, and as we all know, mental health situations can change quickly. But my concerns are for my client, getting him the services that he needs in the most expeditious way that we can, and in a consistent way. And frankly, I just think that his mother being able to provide that to him would do that. Obviously, you know, if there's some sort of harmful or injurious conduct, he's coming back and he's talking to you and he's
Well,
looking
let's
at
bring
10 years.
let's bring his mom forward. Thank you, Renee. We're going to go on the record. The court is calling 2022 CR 11097 State versus Jonathan Kane Allen. Can I have parties announced for the record for the state?
Ashley Jones.
Defense.
David McLean for the defense.
All right. And is that your client, Mr. Allen?
It is, Your Honor.
All right. And we are here because the defense, through the defendant's mother, wishes to have the no contact order lifted and have it changed to no harmful or injurious contact. Is that correct?
That is correct, Your Honor.
All right. And the mother, if you would like to call her as a witness?
I would, Your Honor.
Name.
Okay. Do we need to swear her?
Yes, I'm going to swear, but if you'll
Okay.
call her name for the record.
Absolutely. The defense calls Sally Kane.
All right. Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand if you'll state your name for the record.
Sally Rebecca Kane.
All right, just one moment. Excuse me, in the back, if y'all can just ask the deputy to move you to the back row. All right, you may proceed.
Thank you, Your Honor. Ms. Kane, how are you related to Jonathan? Make sure you speak up nice and loud. This young lady over here has to hear everything.
I'm
we're
his
saying.
mother.
Thank you. At this point, is there a no contact order in place where Jonathan is not able to have contact with you?
I've never actually seen it or known about it except for hearsay.
Okay, but to your knowledge, there is one in place?
Yes, I believe so, from the probation officer's remark.
Okay, and are you concerned for your safety being around Jonathan?
No.
Let me ask you this, does Jonathan have a mental health issue?
He has the very worst. He has bipolar acute schizophrenia, which is voices, monsters, grandeur, contracts for record deals, those kind of things. And the reason that Jonathan is in this situation is because his illness escalated and the medicine couldn't cover it. And he actually went off the rails before we could get into a doctor.
Okay, and so at this point, are you asking the court to remove that no contact order?
I am. And it's very important to me to go to the appointments with Jonathan because I am an observer of the symptoms, the frequency of them, and seriousness of them. And I know the psychiatrist that I used before.
And you realize that if there was another episode where Jonathan perhaps became unstabilized again, are you concerned that he would become violent?
No, in fact, he's a little bit unstable now. The medicines that he's on are not hitting all the marks.
Okay, what medication is he currently on?
You want to pull my phone out?
Is that okay, Judge, if she looks?
Sure.
Yeah, you can refresh your memory,
Oh, as far as the medications?
just for the medication.
Sure.
Text. It was in the text that he sent you.
I had it here just from you earlier, right?
It was in the text.
It's in a text? Well. Okay. That's not it. Oh. Caplita.
Okay, CAPLYTA.
And this is 42 milligrams. And Jonathan, do you take one? Takes one.
Okay, and so to your understanding, is Caplyta a medication for bipolar?
I'm not aware, I'm not familiar with it. It's a
Okay.
new medication to me. But that's the way it works when you start a new medication. You observe it and then you adjust it.
Okay. Do you know if he's taking any kind of an antipsychotic other than the Caplyta?
No,
Okay. All right. And so does he receive that medication from his psychiatrist or does he get that through the MIC unit?
Gets it from his probation officer.
Probation. Okay. Is it your desire that he be able to see his regular psychiatrist and get back on medication that will help him with his mental health issues?
Oh, yes, because he's like actually the best in Texas, Dr. Zufrow.
Okay. All right.
He used to be in charge of the Texas Mental Health Organization.
In the event, let's say the judge lifted this no contact order and there was a no harmful or injurious contact. In the event that Jonathan actually became aggressive and assaulted you, would you hold the state of Texas harmless and not liable for lifting this order?
Absolutely.
Okay. With that, I'll pass the witness, Judge.
Any questions?
Not from the state, Your Honor. The state would ask that we go off record for just one moment. We can
Yes.
find out some information.
All right, yes, we're off the record.
Oh,
sure. Yes, the witness is excused.
Thank you. Thank you, Mr.
Are you all ready?
Yes.
All right, I'm ready to make my ruling unless you all have anything else you wish to add.
Just the information that we did find out from probation, and just for the clarity of the record, is that there was no permission given for Ms. Kane to bring the defendant here today. The permission given was that she could attend the court hearing only. And so I just did want the court to have that information.
All right, so this is what the court is going to order. There's to be no contact. The only exception to the no contact order is the following. She may transport him to his medical appointments and court hearings, and there's to be no contact with minors. Any, Mr. Kane? I'm sorry, Jonathan Allen Kane? All right, these are the court's orders. The only time you can have contact with your mother is if she is transporting you to your medical appointment or to a court hearing. Do you understand?
I wanna appeal this to the Supreme Court,
Okay.
and, I was told not to say anything by, Director
No,
of
you
FBI.
can still appeal it, but for
To the
now,
court.
until that appeal is taking place at the US Supreme Court, my orders are the only contact your mother can have with you is if she's taking you to your medical appointments, which I think both parties agree that he needs to take his, that he needs to see a psychiatrist
Yes,
and
Judge.
that he needs to stay on his medications.
Your Honor, could I request one other thing?
Right.
And I understand that's for physical contact, being in proximity of each other, those kind of things. Is it possible that they could at least communicate to each other via phone or text?
No.
How,
No.
how would she make arrangements?
My
to
understanding
do
is that she has the information about when his medical appointments occurred. That's what, off the record, we spoke about, that she does have that information, so she knows when his medical appointments are. So the only exception for her having contact with him is for his medical appointments, his court hearings. He's not to have, and he's not to come to her home. And when I say come to her home, I mean the home where she is residing with the children, and there's to be no contact with the minors. And yes, sir, you can appeal to the Supreme Court. Your attorney will tell you how to do that.
Thank you, Your Honor. I appreciate
All
your
right, thank you.
consideration. Thank you.
Yes. All right, who's here on Garcia? All right, what is happening with this case?
Yes, Your Honor. Today's our first court hearing. When I had a chance to confer with the state and my client regarding the cases. He has this filed case as well as a number, I believe 4 unfiled criminal mischief felony cases, Judge.
Okay.
So the state, in communicating with them, is requesting time to be able to reach out to the complainants in that case and see about a potential global offer for this case that we have here, Judge.
All right, Norma, on Luis Garcia,
Yes, ma'am.
I need a 30-day reset,
Yes,
and it will be for discovery.
Yes, ma'am.
Yes, sir.
He's also listed as Luis Rivera.
Rivera, yes, Your Honor. So,
All right, so we'll come back on February 24th. Is there
yes, Your Honor.
anything else?
Nothing further, Your Honor. I'll continue to confer with the state in the meantime.
Thank you. Yes.
Sure.
You want to file back on this?
Yeah.
Here you go. You're welcome.
Yes, and he should have a reset form.
Yes.
Yes.
Thank you, Judge.
You're welcome.
Judge, you have the PSI on Omero Sanchez?
Just one second.
Okay.
That case, there, we said February, what date on that one?
I don't know, Heidi. left that
Rebecca
here.
Garcia.
Oh, for
That's
Garcia,
totally different.
I thought you were talking about Sanchez. I'm so sorry about that.
No problem.
February 24th, Judge.
All right, thank you.
It's my mistake.
All right. Yes.
Judge, am I broadcasting? I'm broadcasting. Let me try to be quiet. Mr. Edelman and I are in discussion about a 1244B
On who?
reduction on Jordan Estrada. He's not up in front of the bench yet. He's been in your court for a while.
Okay. I just.
Statute says that we have to request your permission, so we're requesting your permission.
I mean, you all can put it in there, but I need to see, I don't know anything about your case to decide whether or not I would follow that.
It is a PG1 less than a grant, for which Mr. Estrada has 199 days of credit. Defense counsel informed me of a provision of the penal code with which I was not familiar. Section 4B.
Oh, yeah.
States at the request of the prosecuting attorney, the court may authorize the prosecuting attorney to prosecute a state jail felony as a class A misdemeanor. I've never done this.
Oh, no, I've seen it done and I've done it before as a defense attorney.
I'm kind of tickled to try.
Oh, well, here's the question though. Why would I punish him as a misdemeanor? That's going to be the question. And I don't know anything about the case.
Okay.
Okay.
So we'll put on argument in just a minute, Judge.
Okay. All right. Thank you.
Thank you, Judge. Appreciate that, Judge.
You're welcome.
We'll be ready on Estrada in about 90 seconds. Okay, Jordan Estrada. I'm filling out the right to appeal right now. Okay.
Okay.
Karen Joshua Harris. Thank you. Oh, thank you for your patience. Court is calling 2024 CR 009988, State of Texas versus Joseph Joshua Harris. Could I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense.
Nathaniel Nady, Judge.
And are you Mr. Harris?
Yes, Your Honor.
Counsel, have you received all discovery?
Yes, Judge, I believe
Did
I have.
you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Harris, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Harris, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unauthorized use of a vehicle as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Mr. Harris, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
Did you review the waiver repeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be no contact with Ricardo Valera, Valera. And you are not allowed to operate a motor vehicle without a valid driver's license. Did you understand those are recommendations from the state?
Yes, ma'am.
And the court does not have to follow those recommendations? Then to the offense as charged, how do you plead?
No contest.
State any evidence?
Containing exhibit 1 and attachments, Your Honor.
No objection.
State you may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Okay, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We would like to today, Judge. if
Anything you
possible.
wish to say on behalf of your client?
Judge, just that he's a very young man. He's 18 years old right now. He does have a 1-year-old daughter. He does have a plan for what he'd like to do with the rest of his life. He explained it to me. He's actively completing his GED right now. He'd like to do underwater welding, which I thought was interesting, but apparently is a pathway to a good paying career. So he does have a plan of what he'd like to do. Obviously, this is a big wake up call to him. And I believe that if you give him the opportunity to put him on deferred adjudication, that he will hopefully complete that and put this behind him, Judge.
All right, and what is happening with the other case he has?
You're talking about which one, Judge?
The one where he was on an ankle monitor until October 9th, 2023, when it was removed?
He's on an ankle monitor currently, so I guess.
Well,
I
no, this
thought-
is from another case.
Okay, is that still in Bear
With
County?
Officer, yes, with Officer Castro. Do you remember Officer Castro?
Yes, ma'am.
Did you remove that GPS?
Yes, Your Honor.
Why would you do that?
I just wasn't thinking, and I
Like you had other things you wanted to do with your life?
didn't understand until I was 17 the consequences, like the severe consequences of my actions. I didn't know that it would.
See, I'm trying to get into the mind of young people. I don't understand why people don't understand the consequences of taking items that don't belong to you. What do you think is going to happen if you take something that doesn't belong to you?
I'll go to jail.
So, I mean, I don't understand that. You're 18, and I will tell you, here in Texas, plenty of times people have taken people's vehicles while they're asleep, and they see on the camera that somebody's taking their vehicle, and they end up getting shot. And you know what people say? People start protesting, some do, and they say, oh my gosh, that was just a little child. And you know what other people say? Shouldn't have been stealing somebody else's property. And they're just like, oh, well, I can tell you this, nobody is probably going to be bringing charges saying, let's prosecute the person that shot this person for stealing their vehicle. Not going to happen. And then you're 18 and you're working on your GED.
Yes, ma'am. And I have a job right now.
Mhm.
I have a job for 4 months now.
Mhm.
Perfect attendance. And
Doing
I've been
what?
taking care of my daughter. I work at a cabinet shop.
Okay.
I make cabinets.
All right. I don't understand. Young people not graduated from school. They're just out having children. So does your child live with you?
Yes, ma'am.
And who else lives in the home with you?
I live with my girlfriend and my girlfriend's dad and my daughter.
Your girlfriend's father and who else?
My daughter.
And your daughter.
Yes, ma'am.
And see, young people have children and then their parents just allow them, everybody come in and move in. And then people think that's normal to have children when you're not prepared to provide shelter for that child or clothing. Somebody else is going to be doing that. All right. Do you have your driver's license?
No, ma'am.
Then you cannot drive.
Yes, ma'am.
So how do you get to work?
I Uber at the moment.
All right. What's wrong with Via? Does Uber cost, I think Uber probably costs more than the Via bus.
Yeah, around where I live in Selma, there's no Via bus station. It's like no bus stops or nothing.
Come on, America, can we get some great transportation? You know, I travel all over to different countries. Their transportation is top notch. You can get on it and go wherever.
Yeah.
That's something you should be writing your city council, writing your legislature about, saying why. You know, people say Texas is the best state in the world and the best state in the country. And the United States is the best country in the world. Can we get our transportation in order?
Well, and even if you could take via bus, it usually takes so much longer than just a car ride, so.
Well, you know what I would tell everybody? I used to take the Via bus.
Yeah, early.
And yes, I did. So I would end up at the courthouse. And you know what time I would end up getting at the courthouse?
Early.
7 a.m. And I did it because I needed to work to feed myself. I didn't want to pick up the phone calling, Mom, can you pay for my groceries this week? Although she did. I will tell you, everybody has to start somewhere. And I believe in that because my mom would pay my rent. She would give me money for groceries. And this is me with, all right, there's to be regular reporting by Zoom or in person, regular random UAs, probation, see if you can allow him to see if you can allow him to report by Zoom since he has the child that's a newborn and he's working and he's trying to get his welder's license. There's to be regular random UAs. If you're drug tested today, what are the results going to be?
I'm gonna test positive for marijuana.
When's the last time you used?
About 2 weeks ago, Your Honor.
Why you use it and you know you have to come to court? See, these are things that you're not thinking about as an adult. And you know what else? Your child does not want to smell marijuana on you. And then you have your your girlfriend's or fiance's father allowing you to live in their house and you're not doing right. So we're going to do regular UAs, tests for levels. Those levels have better start going down and no marijuana use. You're not allowed to use marijuana while you're on probation.
Yes,
It's
Your
against the rules of probation. You're not allowed to drink alcohol while you're on probation. It's against the rules of probation. You understand?
Yes, Your Honor.
So regular UAs, tests for levels. Field visits 1 time per month until a negative UA. There's to be no driving without valid license. There's going to be 200 hours of community service restitution. I'm gonna order that you get your GED.
Yes,
50 of those hours will be deemed satisfied once you obtain your GED.
Yes,
The other 150 hours, you can do those hours, or either you can better yourself. If you obtain your welder's license, then I will deem the 150 hours satisfied.
yes, Your Honor.
And there's to be no contact with Ricardo Valera, proof of employment within 30 days, no employment as a home health care provider or with minors. And I'm gonna order parenting classes. Probation, anything else?
Judge, would you please repeat the 200 hours of community service, waive 50 upon completion of the GED, and then waive 150?
Yes, if he obtains his welder's license.
Thank you, Judge. Nothing else.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Probation, very important. There are consequences. If you don't report, if you don't follow it through on your conditions, they're gonna end up submitting to me request that your probation be revoked. If it's in order, I'm gonna sign it. And then the police are gonna come and pick you up wherever you may be, because there's gonna be a warrant for your arrest. Then you're gonna be taken to the jail. Either you're gonna make bond or not. If you don't make bond, you're gonna be like them. You're gonna come over in orange, and then I'll make a decision on whether or not you should be revoked or not. From here on out, everything that you do, you need to ask yourself these questions. What I'm doing, is this something that could result in me being revoked and potentially going to the state jail facility for 2 years? If the answer is no, don't do it.
Yes,
If
ma'am.
the answer is maybe, don't do it. Because I will tell you, state jail facility, unless it's overcrowded, if you get 2 years, you do 2 years. And that will be 2 years where your child, when you come out, your child will not recognize you, and somebody else may be raising your child. You understand?
Yes, ma'am.
If you need anything, let probation know. If you feel as they're not addressing it, you can always come back to the court. You understand?
Yes, Your Honor.
All right, so is he on GPS now?
He is, Judge.
What do you all want to do with that? You all still want him on GPS?
Well, no, Judge, it was not part of the plea bargain agreement. I would humbly request that it be taken off, and as long as he's complying with all conditions of his probation, that it remain off.
State, what are your thoughts on GPS removal?
Had any violation reports lately?
I haven't seen any of them. Have there been any violation reports?
Judge, that wouldn't be through probation.
Could you all check to see?
I'll
if
check
there-
right now, Judge.
Have there been any violation reports on you?
No, ma'am.
All right, if there have not been any violation reports, then,
I'm with the GPS on it.
okay. We will see what it says.
You have the excuse from the bench?
Yes.
Thank you.
No, Judge, I don't have any violation reports from pretrial.
All right, the court will order a removal of GPS. Is there anything else you need?
No.
All right, thank you.
Thank you,
Thank
Judge.
you, Your Honor.
You're welcome. Probation will go for conditions. And you have one more with us, correct?
I did, my understanding he's not present today.
All right, we'll take it up. Just 1 minute. All right, who is your other client?
Thomas Wagner.
Do you have
He does.
Thomas Wagner over there? Let me see if it's here.
Here you go, Judge. You're welcome.
All right, could somebody make an announcement for Thomas Wagner in the hallway? Thomas James Wagner Jr. So how has the new year been treating you so far?
Good, Judge. Busy but good.
Was Christmas enjoyed by all?
It was, yeah. We didn't go anywhere this year. Every single time we've gone since my daughter's been born, we would just get like really sick wherever we went. So it'd be like Thanksgiving, Christmas. And so we just said this year, we're not going anywhere. We're just staying home.
Okay. All right, court is calling 2024 CR 011163, State of Texas versus Thomas James Wagner Jr. Could I have parties announced for the record for the state? Defense?
Nathaniel Navy.
All right, this hearing was scheduled at 9 a.m. It is now 3:29 p.m. Counsel, have you had any contact with your client?
So in the past, I have, Judge. He's homeless. He doesn't have a phone, so it's a little tricky for me to stay in contact with him. He's had a misdemeanor court date. He did appear to that. And so I would ask if it's possible to hold off. I might be able to get in touch with pretrial and see if he has any alternative phone numbers that I could try to reach him at and possibly bring him in next week, maybe, Judge. So I don't think this is a situation where he's willingly or intentionally missing court as he appeared to our last court date. We did do a competency evaluation on him and he is competent, but he does have some mental issues as well, which I think correlate to his homelessness. And so I would ask for a little bit of hopefully leeway with this one, trying to get him in by next week, if the court would allow me.
All right, Deputy Mejia, did you make an announcement for the defendant and outside?
Yes.
And what was the response?
Nobody's up.
All right, state.
Your Honor, does this gentleman have a personal bond or a commercial bond?
It's a commercial one.
Forfeit the bond, issue a warrant.
All right. What I'll do, counsel, because you're telling me about the potential mental health issues, I won't do a bond forfeiture. I will do a judge's warrant. And if you're that way, there won't be such an issue with the bondsman.
I see.
So I'll
Thank
do
you, Judge.
I'll do a judge's warrant.
So if he's picked up, he'll stay on the bond.
Yes. Unless they decide they don't want him. So I'm going to issue a judge's warrant. I'm not going to remand him without bond. And if he makes an appearance, of course, the court will reconsider.
Okay, and I'll do what I can to try to get him in as soon as possible whenever at the next available court date, Judge.
All right, thank you.
All right, thank you. May I be excused?
Yes,
All right, have a good one.
you're welcome. Randy Folsom? Yes. All right, and the blood discovery, what did we discover?
At this point, it appears to be still outstanding, Your Honor.
If I remember correctly, the order was signed in December, was it not?
No.
October 10th.
Yes. So this is what I'm going to do. I know we're going to hear the bond issue as well. Did you file a motion or you're seeking to do it orally?
I had previously filed motion, Judge, it's been e-filed, accepted.
All right. All right, we're going to go on the record in 2024 CR 009026, State versus Randy Folsom. If we're going to have parties announced for the record for the state.
Andrew Harris, Edelman.
Defense?
Rene Munoz.
And are you Mr. Folsom?
Yes, ma'am.
All right, we're here for a blood discovery. How long has the blood discovery been pending, state or defense?
Since October 10th of 2024, Your Honor.
State, do you have any idea when that will be available?
You're not.
All right, defense, you're asking for the court to reconsider the bond reduction?
That's correct, Your Honor. Bond in this matter is currently set at $30,000. My client has been in continued detention, not financially able to make the said bond requirements. Due to the delay of getting the records, we're not able to proceed to trial. We're requesting that the court reduce his bond due to the delay. My client also, as a side note, wanted me to assert his right to a speedy trial and the lack of evidence that was requested by the state that we do in good faith believe that is in the state's possession has also violated my client's rights pursuant to 17.151, as the state is currently not ready for trial as the evidence and discovery is still outstanding regarding my client's case.
All right, if you want this, the court can set this for trial for Tuesday.
That's fine.
That's
fine. Your Honor,
Yes.
I apologize for the interruption, but I'm looking at a copy of the standing discovery blood order, and I see that it was signed on December 9th of 2024, not October.
Okay.
And my experience has been that these sorts of blood discovery packets are typically produced within about 90 days of the order being sent to Texas DPS.
Seems that it does say December 9th there, Judge. I was referring to Odyssey, and I think I did see something about October. But if it is December, Your Honor, 9th, all the way in January, my client has still remained in detention and has not been able to make bond, Your Honor. So with regard to the outstanding discovery, we would still maintain the same position that this matter shouldn't be delayed because there's outstanding discovery.
Okay. Just 1 second.
Yes.
Let me look at something here. All right, I do see that on December 9th, there was an amended standing order for blood testing records. And based upon the title, that would suggest to me there was a previous order or no? Or are they just calling it an amended standing order?
I believe it's just the amended standing order, Judge, regarding the blood testing records from DPS.
All right. So let me look here. So you're prepared to go to trial without the blood discovery?
Your Honor, we would prefer that the blood discovery be available in a timely fashion in order to prepare. But if one, if the court could consider reducing the bond, and two, if the court finds it suitable to place a date that discovery on the blood should be produced. If not, it wouldn't be able to be introduced into trial. We would be asking for that. My client's just wanting a fair shot at having the necessary evidence available, but also keeping in mind that he is indigent, he is poor, and he is waiting in custody for a trial to commence.
All right, state, do you have any objection to a bond reduction?
Yes, Your Honor. For Folsom's most recent DWI third occurred in 2019, and he served a sentence of confinement of 5 years for that. So considering a relatively short amount of time between that DWI third and this allegation, a bond reduction does not seem advisable from the state's perspective.
All right, defense, the court will note that this case has been pending, and I've not been given a date of when the blood discovery will potentially be available. The court is going to grant your motion for a bond reduction. Court will set the bond at $25,000. The court is going to order full GPS, ask that the fees be waived, and the court is going to order ignition interlock on any vehicle the defendant has access to, as well as the vehicle that he's alleged to have been driving.
Yes, Your Honor.
Is there anything else from either side?
Not from the state, Your Honor.
Nothing further from.
We can go off the record. Ms. Ferguson, if you'll set this in late February for final discovery, please. All right, February 27th.
Very well, Your Honor, may be excused.
Yes. Who's here on Jessica Doberman? Hello. All right, where are we on this case?
Judge, I'll let Mr. Edram, please.
There is an unrelated misdemeanor collision with damage greater than $200. I would like to contact the complainant in that case and learn from her how much damage she sustained in order to incorporate that into a plea agreement with defense counsel here. I spoke with the complainant. She estimated the amount of damage, but did not know for certain. I should be able to acquire that information within a week.
All right, Ms. Ferguson, can you recall Doberman for 2 weeks, please? And just have it as a discovery setting.
February 6th.
February 6th, counsel?
Can I get you to do the 5th, Your Honor, if you don't mind, the day before?
Ms. Ferguson?
That's a Thursday, Judge.
All right, so you'll need to do it, you can do it that Tuesday.
The 4th, yes, thank you.
All right, Norma, recall it for February 4th.
Yes.
Is there anything else?
Yeah. Judge, under the circumstances, would you consider perhaps releasing her on a PR bond? She's been in jail for about 5 months.
Oh, I'll need you to have them do an interview.
Okay.
So, Ms. Ferguson, could you have our interview for a PR bond, please? Legally, I have to do
Sure.
the interview.
Okay.
Okay.
I'll see you on the 4th then.
All right, thank you.
Thank you. See you.
Who's here on Estrada?
And Judge.
And then after that, it will be Omero Sanchez. All right, where are we on this case?
The state had made a request to the court to proceed as a class A misdemeanor, well, under Penal Code Section 1244B.
Mhm.
And we just need a ruling from the court on that request.
Well, I mean, you all can do that. However, I don't know if I'll accept that plea until I see the facts of the case. I don't know anything about the facts of the case. So you all can do it under 1244 and you can put it down that it's under a misdemeanor 1244. And then once I review the case, then I'll see if that's appropriate or not. There's no way I can say that I'm going to follow your plea agreement until I see whatever the police report says. But yes, you can apply for that.
Reading 1244B.
All right, here's what I'm telling you all. You all can apply for it. I'm giving you my permission to apply for it. But I can't tell you if I'm gonna accept whatever agreement that you all come up with until I actually see the police report. Y'all may say, hey, under 1244, I want him to have 2 days. Maybe I don't agree it should be 2 days under 1244B. Maybe I may agree it should be 365 days. I don't know until I see everything. But do y'all have my permission to apply for it? Yes. Does that answer everybody's question?
Not really, Your Honor.
Okay, Judge, let me cut to the chase, okay? To translate everything that you just said. You want to see the steps.
Yeah.
In the story, that both the sets of steps.
Yeah.
No application for probation, bada bing, bada boom.
There we go.
I think we got it, Judge, thanks.
Thank you.
Thank you, Judge.
All right, are you all ready on Sanchez, Omero Sanchez?
Have a seat, sir.
All right, court is calling 2024 CR 008247, State of Texas versus Omero Sanchez. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense?
David McLean for the defense.
All right, and are you Mr. Sanchez?
Yes, Your Honor.
All right, you entered a plea on December 2nd to the offense of aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. The state is silent on your application, and they're silent on, they're just silent on your application. There's a $1,000 fine. There's an affirmative finding of family violence. Have both parties had a chance to review the PSI report, state? Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
Not for the defense.
And have both parties had a chance to review the MIC evaluation? Was that completed?
I don't believe in make evaluation. I didn't see one, Judge.
I did not see one.
All right, that was audit.
Sorry, Judge, can you give me the case number?
It's 2024 CR 008247.
That's the evaluation was the top evaluation and the PSI.
All right, and what are the results from the MIC evaluation?
You know, I'll be first.
All right, thank you. After you all have finished reviewing that, just let the court know.
I'm ready, Judge.
All right, any objections to the MIC evaluation, state or defense?
No, Your Honor. No, Your Honor.
All right, defense, do you have any witnesses?
Other than my client, no.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Omero Sanchez.
All right, defense.
Thank you, Your Honor. Mr. Sanchez, you had a chance to review the pre-sentence investigation with me, correct? Okay. And the information that was contained there that the court now has available to them, that was all true and correct, right?
Yes, sir.
Okay. On the night that this happened, can you tell the court where you were mentally?
I was, I had I guess it was one of the first times I've had this, a sinking feeling in my chest, a flashback. The night before that, I was in Hondo. I was a Starbucks store manager. I was helping my district manager to open a store then. And because I was a veteran, they sent me down to the VFW. And while I was at the VFW, remember the last thing we did was we presented arms to the flag. And as soon as I rendered a salute, without even thinking about it, my heart just sank, and I felt sick to my stomach. And I was back on Disney Drive, back in Afghanistan, and that's the road that we would send off our soldiers, airmen, Marines. I felt very sick, very sick. The very next day, the day of the incident, I talked to my district manager, George Martinez, and I told him everything, and actually cried with him. I hadn't cried in can't remember. So I wasn't in a to answer your question, I wasn't in a good state of mind. I didn't feel well. I did end up, and then the incident happened at night where I found my mother and my children, my ex-girlfriend, with the victim, Mr. Quintanilla. And then that's I think what pretty much broke the rest of me mentally.
Okay.
That's definitely not who I am. But to answer your question.
And with the events that were delineated as to how that happened, that's contained in that pre-sentence investigation report that you gave, that description was accurate and truthful?
Yes, sir.
Okay. Do you accept responsibility for what happened that night?
I absolutely do, sir. Regardless of how I feel or what happened, I know what I did. No one deserves to be hurt the way that things went down. I would never want to harm another person. I hope one day that Mr. Quintanilla can forgive me. I am truly, truly sorry. It's not a good feeling to have, and I hope that I just would like to pay my debt back to this community.
You ever been in trouble with the law before?
I never even as much as a parking ticket. I've always considered myself a productive member of society, a law-abiding citizen. 14 years in the Air Force. I was a military instructor here at Lackland. I've always volunteered for food bank. Always been a part of this community. In that regard, it's just that's not who I am. But I do take responsibility for that.
If there is restitution that's owed, is that something you're willing to pay to Mr. Quintanilla?
Absolutely. Whatever the state feels is right to make this right, I'll do whatever.
You've asked this court for deferred adjudication.
Yes, sir.
You understand deferred adjudication is a kind of probation that if you complete it successfully, your case will be dismissed.
Yes, sir.
You also understand that while you're on probation, if you violate any terms of that the state can file a motion to enter adjudication of guilt, issue a warrant, go back to jail, find out, not. At some point, you're going to come back and you're going to face the same judge. And at that point, the only decision she's going to have to make is whether to enter the plea you've already given her. You understand that?
Yes, sir.
And if she decides to enter that plea, she has the full range of punishment up to her.
Yes, sir.
And we've discussed what that range of punishment is, from 2 years up to 20 years in prison.
Yes, sir.
And while you're on probation, is that something you're going to consider every waking moment of your life while you're on probation.
Absolutely.
20 years and $10,000 if you violate your probation.
Yes.
Is there anything else you'd like to tell this court?
I would just like to reiterate that I would like an opportunity to make this right. I know I've changed a lot of people's lives, 3 of us. Like I said, I am deeply troubled and sorry for the actions that happened that night. It was a very complicated night. It's not a representation of who I am, the person that I was before this case. I would also, on a personal level, I would cherish the opportunity to be able to provide for my children again. That would mean the world to me. But at the same time, I do acknowledge that what happened. So if it's prison, then fine, I'll pay my due that way. If it's further education, then I would really cherish that opportunity. And I know I'll be successful. There's no doubt in my mind, but like I said, I understand the situations. I've also been taking a lot of classes while I'm here in jail. I wanted to run certificates, but it's helping a lot with my mental health.
What classes did you take?
I took anger management, I took MRT, moral recognition therapy, took paint, art class, and then PTSD class with Ms. Alma.
Do you currently have a diagnosis with PTSD?
I guess through Ms. Alma, but they want me to, if I do get a chance to get out, they've already kind of made some calls to go give me stuff with the VA, give them my benefits. I've never filed for them. So.
Okay, and you do have benefits available through the Veterans Administration?
Yeah, they told me basically I'll get 100%. The whole thing. I never wanted to deal with the military events.
State? No questions, Judge. I have a few questions if there are no objections.
No objection.
All right, so what was the argument about?
The mother of my children, Ms. Galvan, she was, I caught her cheating.
Well, I mean, it states in the stipulations that she hadn't dated you for years.
No, we were together for 6 years. We had 2 kids together. We were on a lease at Keltan Smith's apartment in Chivas. We were living together. I had no idea this was going on. I actually went to her for help because I was feeling really sick that night. And I just happened to, no, I mean.
No, I read that you all hadn't been dating for a while. Did I read incorrectly?
No, we were together for all the way up till April of this year.
My understanding was that was kind of her statement, but I think from my client's perspective, they were living together still.
I had no idea that was going on.
Yeah.
All right, so it says in the stipulations that you came over to the home, correct?
No, ma'am, this is in a parking lot. I went to, because I was feeling sick, so I was trying to find her, someone to talk to her about the incident I had. Because she went with me to the veteran event the night before. I took her and the kids. And then so the following day, because she worked late, she worked at Walmart. And I basically found them in the parking lot. But yeah, we were together. I mean, there was no question about that.
Oh, all right, so that was me not interpreting this correctly. So it says that victim 2 advised that she was assaulted by her boyfriend of 4 years, which is you. Victim 2 also advised that she had been in a relationship with victim 1 for the last couple of months. So you go to the parking lot and you realize that she's been cheating on you.
Yes.
All right. What do you mean you caught them?
They were kissing and.
All right, why were you at that parking lot? Is it the parking lot of the apartment complex?
No, it was a business next to their work. They used to work together.
Okay, so they used to work together.
I don't know if they still do, but they work together.
All right. So you went to her place of employment to talk about your issues?
Yes, because I talked to her previously around lunchtime. That I left work early, got the kids from daycare. But yeah, that's pretty much the gist.
All right, so then you leave the location because it says that you started striking her. And you shoved her into the vehicle. This is just in the stipulations. And she states that during the altercation, the person that she's with took out his firearm and pointed it at you, demanding that you leave. And then it states that, I'm just gonna say her boyfriend states that then you walk away and you get into your vehicle. And then you make a U-turn and you accelerate towards her other boyfriend and towards her. And then you collide with her, with the vehicle. Then you exit your vehicle, start striking her boyfriend several times while the boyfriend is laying on the parking lot. And then you fled the location. Is that about right, sir?
Not to my account.
Okay, what is your account?
Brought them in the parking lot. And this is where I lost control. I normally wouldn't do that. So I went at them. The thing that I remember is he struck me in my neck and then I started fighting with him. He ran away, pulled out his concealed weapon behind his back. That part is what I lost all thought, because the last time someone pointed a gun at me was in Afghanistan. And I hate guns. I don't do guns. I can't stand guns. I have a real problem with guns. I got back into my car. I couldn't exit the parking lot without going back that way because there was only one exit. So that's why I did that. But the whole time I was just thinking about the gun. I hit him with the vehicle. I didn't run him over or anything. He fell to the side and then I got out trying to find the weapon. I wanted to take control of that weapon. Yes, I did strike him. Even though we're fighting, I was still afraid that he was gonna shoot me with the weapon. At that point, I had lost control of most of what I was thinking. I was more in like just disable the threat.
Okay.
And then she remember her coming up behind me afterwards and grabbing me by the neck, and that's where I shoved her back. I shot some threats at her, and then a bystander came by, and that's when I kind of snapped out of it. And so he had 2 kids with him, and that's when she had the gun towards the end, and then that's when I left the scene. I just didn't know.
All right, thank you for explaining that and clearing that up for me. Any other questions?
No, Judge.
Any other questions?
Just wanted for clarification, when you were driving your vehicle toward him, was he pointing the gun at you?
I don't remember, but in my head, he had the gun, and that's all I was thinking about.
There.
All right. Well, isn't the complainant here, Mr. Quintanilla?
Yes, Your Honor.
All right, if anybody wants to ask him whether or not he was pointing a gun at him,
The state will stick by the stipulations.
the
Good,
complainant is here.
I don't have any reason to question.
Okay. All right, is there anything else?
Not from the state, Your Honor.
That has cleared up some things for the court. So what does the complainant want? Because I see that the girlfriend that you all are fighting over is not here and hasn't given anything. Is the girlfriend here?
She's here.
Oh, they're sitting separately. Are they no longer together?
No, they're together.
My understanding is they are both separate for he's one giving the victim impact statement.
Oh, okay. Is there anything either one of them would like to say? Or do they, I mean, what would they want to see happen in this case?
He just wanted.
Sure.
Judge, I would kind of object to that because the state was remaining silent.
Well, let me just tell you, it's probably for your benefit.
Understood. Thank you, Judge.
And to the complainant, just know if I were to give him probation, he is going to be on GPS and there would be no contact.
I will say that the state, is going to remain silent, but, so I have the information, I just, they're remaining silent.
Okay.
So I don't. I thought I heard to him like at 2.
Oh.
Oh, okay.
Yeah.
Well, there's no objections then, our, the victim would like prison time, and, the girlfriend, Vivian, who is not a stress victim, said that she, just wants what's fair.
Okay. All right. Well, I'm going to do what I believe is fair in this case. And I'm assuming he has no criminal history?
No.
And were you dishonorably discharged from the military? I'm sorry?
It was
Honorably?
I had a great career.
All right, this is what the court is going to do. The court is going to sentence you to 8 years deferred adjudication. There's $1,000 fine. That will be probated. Is there any restitution?
Not in.
All right. The state is asking for an affirmative finding of family violence. I'm assuming there are no objections to that finding.
No, you're right.
All right, there's an affirmative finding of family violence. There should be no contact with Anselmo, ANSLMO, Quintanilla, or Vivian Galvan. If you want to have visitation with your children, that needs to be done through a third party, you understand?
Yes, sir.
Are you employed?
Not at the moment.
All right, there's going to be partial GPS for employment. There should be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. There's going to be anger management. Field visits 1 time per month for 6 months. And I'm going to order that you receive mental health treatment through the VA.
Yes.
So probation, it'll be mental health treatment through the VA. And the partial GPS will be until further notice. And I'll ask that GPS fees are waived.
Thank you, Judge.
Probation, is there anything else? Is there anything else you need from the court to be successful?
No, Your Honor. Thank you so much for the opportunity.
You're welcome. And also, I'm sorry, it's an affirmative finding of deadly weapon. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it inside?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your
All right, we can go off the record. So in this court, to be successful on probation, communication is key. If there is an issue, you need to let the probation officer know. If you feel as though they're not addressing the issue, then you can always come back to the court. Do you understand?
Yes, Your Honor. Would I be able to speak to you or?
Oh, just 1 second. I'm so sorry. Also, probation, it's 150 hours of community service restitution. And I'm gonna order parenting classes. Once you complete that, the community service hours will be deemed satisfied.
Thank you.
And you were asking?
If I have questions, I could speak to somebody in here.
You speak to your probation officer. There's a probation officer here. That probation officer will go over conditions with you, but she is not going to be your regular probation officer. That will be a different probation officer. If you have issues or you need help with something, let them know. If you feel as though they're not addressing it, you can come back to the court and address it with me. Do you understand?
Yes, Your Honor.
All right. In this court, make sure you communicate. And if for any reason a motion to revoke is filed, if it's in proper order, I'm going to sign it. And then you're looking at potentially 20 years at the prison. You understand?
I understand.
All right. Thank you. You say there's a victim impact?
Yes.
All right. If you'll step over there.
With your back against the.
To answer the judge's question, I had holstered my weapon. I had allowed you to leave. I had eased the situation. It de-escalated, and I allowed you to shouted threats at me that you were gonna kill me. There was an exit in the direction that you were going. You did turn that car around and you hit it. I fractured ribs, I fractured leg. And then, what, 4 or 5 months later, still had the nerve to message me that you saw fear in my eyes that night. That you were gonna take my life. You're standing right here in front of you, dude. There is no fear in my blood. Promise to that. What I have is I have forgiven you. I have let that go. What I've been doing is I've been living my life. No ill will towards you. You're free to live your life. All I'm gonna ask in return is that you take that appreciation, right? You get to breathe, right? Look good. With those fractured ribs, it hurt. Fractured leg, I couldn't walk for months. All right? So all I'm saying is appreciate what you got. Good health. The ability to watch your kids grow up. Okay? Have that opportunity, take it. And in return, let me live my life. Leave me alone. That's it.
And I'm sorry, excuse me, nobody mentioned any restitution. Was there restitution?
I wanted money.
Okay, all right, thank you. All right, whenever you all are ready.
I gotta get the bosses, okay?
Okay.
I'm missing a signature. And Judge, just to reaffirm on Mr. Navy's client, where you said don't remand him, right? Just the bond as it is. Okay, just wanted to double check. Thank you.
Not in the body. Oh, you have this here. I just thought it was Alex's chair. He left. He'll come out. Let's go. He's in the loop. He's in the loop. Whatever that is. No. Yep.
That's what I was like. It's so much stuff outside of our hands.
McLean, could I see you, please? Deputy Lauren, could you call IT to come down and tell them that I need another mouse? This mouse doesn't work. So, pig burger.
Oh. I'll just throw my card at him.
Yeah.
We're ready on Estrada, Judge.
Yes, you're all ready?
Yes, Judge.
It's set.
All right, the parties on Estrada, please.
Can I bring him up? Tell him to come up.
Estrada.
I copied you on that email.
Court is calling 2024 CR 007673 State versus Jordan Estrada. Can I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense,
Ted Wood for Mr. Estrada.
are you Mr. Estrada?
Oh, yeah, man.
Yes, Your Honor.
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Estrada, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you proceeding, counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
I think so, Your Honor.
No.
All right, this is a possession less than a gram, is that correct?
Apparently, we're not.
We made the request to proceed on 1244B, Judge.
Okay.
That's a felony indictment.
I know, that's
Okay.
what I'm trying to. We're getting there.
Suss out. Okay,
Yes,
Judge.
okay.
Got it.
So, on all of the court's documents, not the documents that you filed, it says that this was filed as a possession of controlled substance penalty group 1 gram to 4 grams. So I'm assuming, because I haven't looked at the steps yet, I am assuming that it's actually only possession less than a gram.
Judge, the 1 to 4 gram assessment was made while the narcotics were still in the syringe. The narcotics were ejected from the syringe and weighed and came in at 0.155.
Oh, so,
Yes, less than a gram, Your Honor.
all right. And y'all are asking to proceed not on the indictment as presented, but you're asking to proceed on the 1244B.
Correct, Your Honor.
Yes, Your Honor.
All right, so then what I can tell y'all is now that I know, and I've read the stipulations, which I never read before they've been presented to me in evidence. But now that I know it's 0.155, there needs to be some slight changes in the paperwork for the plea bargaining agreement. So just a slight change. You all need to say that you want it to be Class A misdemeanor conviction in charge. And you need to say that it's 1244B just on the paperwork, so there's no confusion with the jail and in case he has any other charges.
May Mr. Edelman and I
Sure, just
edit
put-
this here?
Yeah, just put
Thank
the
you so
B on
much,
there.
Judge.
All right, so parties are requesting to proceed on the 1244B, is that correct?
Yes, Your Honor.
And I'm assuming there are no objections.
There are no objections, Judge.
No objection for me, Your Honor.
All right. And Mr. Estrada, you have no objections to the court proceeding under 1244B?
No, ma'am.
And has that been explained to you?
Yes, sir. With the attorney.
Well, let me explain it to you because I want to make sure that you're aware of everything.
Thank you, Judge.
Yes. So instead of this being a felony conviction, sometimes 1244, it's a conviction, you receive misdemeanor punishment, but it's listed on your history as a felony. Your attorney is asking that you have a conviction, but that conviction be listed as a misdemeanor with misdemeanor punishment. Do you understand? So, sorry.
Yes, Judge. Yes, Judge.
All right, so it will not be a felony conviction. Do you understand?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am. Yes, Your Honor.
Judge, I explained to him all of his trial rights, including the section regarding, I think it's Article 3850, where bodily fluids are taken, that did not apply to him, that sex offender registration did not apply to him, and that all of his trial rights come back if he's ever in front of the court again.
All right. So because we're proceeding under 1244B, and that's as a misdemeanor, is a misdemeanor conviction, your range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea, court doesn't have to follow your plea. If I don't follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
And then I also explained to him, Judge, that they come back again if he's ever in front of the bench again.
All right, and the other thing I'm gonna ask that you all do in your paperwork, I would ask that you all, that you just cross out the, where it states that his admonishments about possessions of firearms, that doesn't apply to him. So,
You know, Judge, every day in court, you learn something.
I have them do that because I may be gone, the court reporter may be gone, we may have won the lottery, and not be here. If
Understood,
that's the
Judge.
case, if anything happens, it will be there for you, so you can say, this is what the agreement was.
Thank you for your professionalism, Judge. Appreciate that.
You're welcome. Now, on that, I can stop getting so many spam calls.
You go. Thank you. I'm sorry, Judge.
Oh, spam calls.
Oh, okay. I have nothing to do with this.
And let me just check one more thing, okay? All right, counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Estrada, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargaining page with your attorney? Did you understand that?
Yes, Your Honor.
According to the plea, the state is asking that your punishment be assessed in 199 days, in the Bexar County Jail under 1244B, and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, it is, Judge.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, were there any such motions?
No, Judge.
Then to the misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Stated in Exhibit 1 in attachments, Your Honor.
No objections, Judge.
State you may be excused. Did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and submitted and stipulated to testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will find you guilty under 1244B. Are you ready to proceed with sentencing?
Yes, I am, Judge.
Anything you wish to say on behalf of your client?
Judge, I just want to express for Mr. Estrada the appreciation for both the court and for Mr. Edelman to give him this opportunity to rebuild his life without the opprobrium of a felony conviction. It goes to difficulties in establishing a relationship with San Antonio Housing Authority, difficulties with San Antonio Apartment Association, difficulty in applying for jobs. The list goes on and on and on. I hope Mr. Estrada moves forward with an appreciation for how close he came with the sword of a felony conviction and expressed his appreciation to this court that all he's gonna have coming out of this is a Class A misdemeanor conviction.
Then the court will sentence you to 199 days in the Bexar County Jail. Is this a judgment satisfied?
It is, Judge.
All right, the court will show that the judgment is satisfied. Did you review the document entitled trial court certification of defendant's right to appeal with your attorney? Did you understand it?
Yes, Your Honor. Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. If you have a drug issue, it appears that you do. There are plenty of places in San Antonio that will help you for free. If you continue using, you know what's going to happen? One of two things. One, you're going to end up in prison or end up back at the Bexar County Jail. Or two, somebody's going to be called down because they're going to say there's a body in the field and somebody's going to have to come and identify your body. You're going to have to say hyper vigilant every day. Take it 1 second at a time, 1 hour at a time, 1 day at a time. When you're released from jail, they'll probably release you at midnight. If you can't find a place to go to get help, I'll be here tomorrow. You can always come in and I would direct you on a place to go. And I know your attorney, who is an attorney in felony drug court, can direct you where to go as well. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome.
Thank you for your courtesy, Judge. May I be
Yes, sir.
excused, Judge?
Yes.
Thank you, Judge.
Thank you.
Okay.
Number, what page is Estrada on?
Page 1.
Thank you. All right, and can you give me the rest of the files, please?
That's all I have, Judge.
Thank you. Bye.
Ron,
Yes,
do we have anything from today's document back tomorrow?
I am going to see